is the buyer's agent responsible? Was he or she competent? Was she maybe not responsible and took the responsibility on herself to ensure, to ensure that this was the case? Like, find me a place where I can do this. Maybe that fact pattern opens her up to liability, where she would have said, you know what, I'll find you some places, but you need to like find an attorney or whatever. Or is just simply getting a title insurance sufficient to a reasonable person to not be liable?
I think title insurance.
She had her.
I'm sorry, I didn't see you.
Didn't the listing agent disclose on the MLS that farm animals were allowed?
Then I think that would be reasonable.
I mean, I think they're all liable, but when it comes back to the buyer's agent, she's gonna say, well, she had that on here, and then it's gonna go back to the title company, and then the title company's gonna say, well, you should check the city ordinances or whatever. She's like, you should, ordinances. She's gonna be like, you should have known that.
When I bought my property in Roman Forest, I actually put in the special provisions that must be able to be used for livestock and other animals on it. And that way it brought attention to the title company and everybody else. But I also went further and contacted the city of Roman Forest and found out that it was on property that was owned by the golf course. When the golf course went defunct, it had no restrictions the city has. Again, it comes back to the realtor knowing the area that they're selling in. That has everything to do with it.
I'm just thinking, I mean, title, of course, you know, to do their research, the deed restrictions. And then at that point, I'm deferring to a real estate attorney because I'm not trying to figure it out. And I don't want the liability of it.
My thing, and I didn't know off the bat, my guess is that there's some exclusion, some like general exclusion in the title policy that they can point to, maybe. I don't know, because not every ordinance and situation could be covered. Like, title didn't even know what the intended use is of the property. They didn't know that
Well, you
this
gotta
was
know
a
the
deal breaker.
HOA too, because most HOAs forbid that.
Yeah, right. That's how it would normally pop up. I guess the title insurance company's job, now that I'm talking through this, would be just to literally flag the ordinance.
Well, you brought up a good point because it's on the contract. You put what the use of the property, like what you want to use the property for.
Right.
So if the agent doesn't put it, then how is the title company supposed to know?
Right.
Yeah.
And if that's important to your buyer, it's damn well worth the contract.
Yeah.
Right.
That may be one of the determining facts in this, talking through this, is just whether the buyer disclosed that. And if what lawyers would do, and we do this in commercial transactions all the time, we just have the other side represent that it's so. And even when they don't know. So that's a big fight in commercial deals when you're buying or selling a business. It's a hard representation versus to the seller's knowledge or to buyer's knowledge, which softens it, or no representation at all. So we view representations as insurance. We don't view it as literally as like, oh, you really had to know. So you saying that there's no environmental issues, you're giving me an insurance policy. Because if there are, regardless of whether you knew about it or not, it gives my client recourse against you to sue you. Okay.